Everyone, should I admit?
Hello?
Good afternoon, everyone. Do we have Mr. Gertson on the phone connected now?
I'm connected, yes.
Okay, thank you. I'd like to welcome you all to the Office of Tax Appeals, and this is the hearing of Fishbone Apparel, Inc. Thank you all for attending today. And just as a reminder, before we get started, that this hearing will be live streamed and available to the public on OTA's YouTube channel. And we are not on the record just yet, so I'd like to cover a few preliminary matters first. First, my name is Seth Elsom. I'm a hearing officer, and I will be leading this hearing today. On the panel today, excuse me. Mr. Gertson, could you please mute your microphone if that's you in the background? Thank you. On today's panel, in addition to myself, it is Administrative Law Judge Asaf Kletter and Hearing Officer Erica Parker. While I'm the lead for the purpose of conducting this hearing, all three panel members are co-equal decision makers in deciding this appeal. Also present is our stenographer, Ms. Alonzo, who is reporting this hearing verbatim. To speak, please unmute the microphone and remute the microphone when you're finished speaking to avoid feedback and background noise. To ensure we have an accurate record, we ask that everyone speaks clearly and loudly. Please state your name before you speak one at a time, and do not speak over each other. When needed, Ms. Alonzo will stop the hearing process and ask for clarification. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The hearing transcript and the video recording of this hearing are part of the public record. And finally, please remember, as I mentioned earlier, these proceedings are being broadcast on our YouTube channel, and any information shared during this hearing will be heard and or viewed by the public. With that, I'd like to ask the parties if you have any questions before we go on the record. Judges, are you ready to go on the record?
I'm ready.
Okay. We are opening the record in the appeal of Fishbone Apparel, Inc., case number 2302-12546. This matter is being held virtually before the Office of Tax Appeals. Today's date is Thursday, July 24th, 2025, and the time is approximately 1:04 p.m. My name is Seth Elsom, and I'm the lead hearing officer for this appeal. With me today is Administrative Law Judge Asaf Kletter and Hearing Officer Erica Parker. As a reminder, the Office of Tax Appeals is not a court. It is an independent appeals body that is staffed by tax experts and is independent of the state's tax agencies, including the Franchise Tax Board. And with that, I would like to ask the parties to introduce themselves for the record, beginning with appellant. Mr. Gertson, you can go ahead and unmute and introduce yourself.
Yes, Frank Gertson, representing Fishbone Apparel.
Thank you. And Franchise Tax Board, can you please introduce yourselves?
Alyssa Pinerbossi and I with Topher Tuttle for the Franchise Tax Board.
Thank you. And now we're going to go over the issues to be heard in this hearing. As confirmed at the prior pre-hearing conference and in my minutes and orders following the conference, the issues to be decided in this appeal are: 1, whether appellant has established error in FTB's proposed assessment; 2, whether appellant has established reasonable cause for abatement of the late filing penalty; 3, whether appellant has established a legal basis for abatement of a filing enforcement fee; and 4, whether appellant has established a legal basis for abatement of interest. Now I'd like to move on to the admission of exhibits as evidence. And Mr. Gertson, we'll begin with you as a representative for Fishbone Apparel, Inc. As noted in the pre-hearing conference, appellant was provided with the opportunity to submit its opening brief as exhibits, and Mr. Gertson, you had agreed to. These exhibits were listed in the pre-hearing conference minutes and orders as exhibits 1 and 2. FTB did not object to the admission of these items. And FTB, I wanted to confirm with you now that you still do not have any objection to the admissions of these items 1 and 2 as exhibits.
That's correct. Thank you.
Thank you. Okay, appellant's exhibits 1 and 2 are now admitted and entered into the evidentiary record. And we're now moving to Franchise Tax Board. FTB, you have submitted 14 exhibits that were labeled Exhibits A through N. These exhibits were submitted by the Franchise Tax Board prior to the pre-hearing conference. Appellant was asked to review the exhibits and indicate in writing whether it had any objection to the admission of FTB's items. Mr. Gertzen, you did not provide any written objection to OTA, and I just wanted to confirm that you still have no objections to the admission of FTB's exhibits A through N as evidence.
That is correct.
Thank you, Mr. Gertzen. FTB's exhibits A through N are now admitted and entered into the evidentiary record. Now we're going to move to witness testimony. And Mr. Gertzen, you indicated at the pre-hearing conference that you plan to provide witness testimony on behalf of appellant. So I will swear you in before you begin your presentation so that any factual statements you make during the presentation or in response to any questions may be considered as evidence by the panel. And I will swear you in just a moment here. But before I do that, just going to again go over the order of the hearing. As noted in the minutes and orders, Mr. Gertzen will present first on behalf of appellant and will have approximately 15 minutes for the presentation. Following appellant's presentation, FTB will have the opportunity to ask appellant questions regarding appellant's testimony only. The panel will then be given the opportunity to ask any questions they may have for appellant. Following that, FTB will have 20 minutes for its presentation, after which I will again turn it over to the panel for any questions they may have of FTB. And finally, appellant, you will have an additional 5 minutes for rebuttal or a closing statement. And then after you finish your closing statement, Mr. Gertzen, I'll do a final check with my panel to see if there are any remaining questions for either party. So with that, I believe that we are ready to begin. And before we do that, I'd like to ask either party if they have any questions before I turn it over to Mr. Gertzen for his presentation. No questions from either party? Okay.
No.
Mr. Gertzen, even though you're connected telephonically, I'd like you to ask you to raise your right hand and state whether you state that you do swear or affirm to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you, Mr. Gertzen. You may begin when you're ready, and you have 15 minutes for your presentation.
Thank you. The respondent has provided over 50 pages of exhibits to the Office of Tax Appeals, with the notable fact that none of these exhibits demonstrates any evidence whatsoever of taxable sales in the state of California. The respondent is presuming its determination of tax is correct. Its assumption does not meet any minimum threshold under Section 23101 of the California Revenue and Taxation Code, or any other relevant section or subsection, and is not reasonable or, for that matter, rational. The respondent presumes that the appellant has made sales in the state because of the appellant's self-reported filing with the CDTFA. On numerous occasions, the respondent was notified that this filing was coerced upon the appellant to quickly settle outstanding issues with the state and did not truly reflect sales in that state. Furthermore, any assumption that those self-reported sales are actual sales after the appellant's statement is far-reaching. The respondent has never provided actual proof of any taxable sales in the state of California, yet it has admitted to having information reporting inventory in warehouses or fulfillment centers in the state. No report has been provided with the information of what that inventory is, was, or who it was sold to. The appellant would argue that if this inventory did exist and the respondent was aware of it, as they allege, then why hasn't that specific nature of these items been presented in this hearing or in an exhibit? One can only presume that the inventory never did really exist, or the inventory was never really sold in the state. Therefore, the respondent's determination that the appellant was doing business in the state of California during 2019 is faulty, since its entire assessment is based on the appellant's self-reported CDTFA return and or the reports of alleged inventory. Since the respondent cannot possibly know why, how, or for what extenuating circumstances the tax filing was made, their presumption based on this information must be determined to be faulty or made in error. Additionally, any assumption that inventory merely stored in an Amazon warehouse in California meets the definition of a retailer engaged in business in California is ridiculous and faulty on its face. Nothing has been provided to demonstrate the nature or the quantities of these items in the warehouse. Amazon inventory alone is not evidence of taxable sales in the state of California. There is simply no correlation between the two. Amazon does not have warehouses in every state. Inventory in a California warehouse can be sold into neighboring states. Never having been provided with a list of these items, the quantity of these items, it can easily be asserted that these items, if they existed, were sold outside the state of California. Also, if there were items in the warehouse, it is possible, depending on the nature of the items and of course the quantity, that these items could have gone unsold. Since the respondent has not provided any evidence whatsoever of the contrary, it can easily be asserted at this time that these items, if they existed, went unsold. The respondent has tried to provide detailed information on nexus, which in this case, the appellant feels is irrelevant. Since the appellant did not have any sales or taxable sales in the state, therefore nexus is moot. The appellant's Amazon reporting, which the respondent apparently has access to, shows 0 sales in California during the time period in question. Since Amazon picks, packs, and ships all of our items, we must rely on their reporting system, which shows 0 sales. Lacking any actual evidence of the respondent, from the respondent, and having only, in the respondent's words, presumption that determination of tax is correct, the appellant can find no other decision except that the respondent's assessment was made in error for this taxable period. Thank you.
Thank you, Mr. Gertson. You have approximately 5 more minutes if you'd like to continue, and if there's anything else that you'd like to add before I turn it over to FTB for any questions regarding your testimony.
No, that's fine. I'd only asked for 5, but they gave me 10.
Okay. Thank you, Mr. Gertson. Franchise Tax Board, did you have any questions for Mr. Gertson regarding appellant's testimony only?
No questions. Thank you.
Thank you. I'm going to now turn it over to our panel. Judge Clutter, did you have any questions for appellant?
This is Judge Clutter. I just have one question. Mr. Gertson, you mentioned that the Amazon reporting said that there were 0 sales. I'm wondering, where is that in the record?
Where is the report?
Yeah, like where is the evidence that 0 sales were made according to the Amazon records? Is that one of the exhibits in the record?
No, via blank piece of paper. And I didn't feel that it would be productive to enter a blank piece of paper. When you report, when the report comes out, it's a blank piece of paper.
So I'm just trying to understand. So when you go to the Amazon website, you can print out a report of how many sales you make by state, or can you walk me through the report or how you access it and what it says?
Yes, you can go on the back end of your selling account and you can print a report of sales. And then if you sort that by state, you can see each sale by state. So there's no California on the report. I guess I should have submitted the report with no sales in the state of California.
So just so I
Yeah.
understand, so like it would tell you, let's say you made sales only in Texas and Nevada, it would say Texas sales this number, Nevada this number. Is that the only
No,
information that's going to report?
It would list every customer. It would list every individual sale, and then the address. And one of the columns would be the state. So it might, if you made, it wouldn't give you a total by state, but it would give you, if there was one sale in a state, then it would be the total. But if there were 3 sales to 3 individual customers, then there would be three rows on the report. But if there are 0 sales, there'd be 0 columns on the report.
And does the report provide a total of how many sales were made in that year? So for example, if you sold to 3 customers, 1 in Texas.
Yes, it would. The sales report would show you that for the time period given. And that is my exact point, and I'm glad you brought that up, that the respondent has provided over 50 pages of exhibits. Okay? They've also provided information that they have a direct relationship with Amazon. And they had gotten reporting from Amazon about inventory in the warehouse. Okay? And so my whole point is, if they have this relationship with Amazon, why are they asking for a report of inventory in a warehouse, as you can clearly see in their exhibits? If they want to prove sales, why don't they produce the report of sales in the state of California? Okay? It's not my position that I'm trying to prove that I don't have any sales. They're trying to prove that I do have sales. Isn't the burden upon them to prove that I do have sales in California?
Well,
why don't they have 50 pages of exhibits? They have a relationship with the Amazon Corporation. Why is it that they don't have one single report with one single sale? They don't exist. That's why. I mean, clearly, if there were sales that existed, they would have these reports.
right, Mr. Gertzen, I understand you and thank you. You've answered my question. I appreciate it.
Okay, thank you.
Thank you, Mr. Gertzen. Hearing Officer Parker, did you have any questions for appellant?
No, I have no questions. Thank you.
Thank you. Mr. Gertzen, I did have one question for you, and that's, do you receive any report from Amazon that shows the location where the inventory is stored? And I believe you had mentioned that, if sales are occurring outside the state, presumably they'd be stored in a location near that state so they could be shipped out or something to that effect. Can you explain any information you receive from Amazon that states where the products are shipped from or how they're stored contractually?
We don't actually receive information. We have to go in to the system and pull that information out if we need it.
Okay. Do you have access to that? Can that be provided?
I do have access to information on where inventory is stored, yes.
Okay.
But from the tax year 2019, I do not.
Okay. Go ahead. Sorry.
I was going to say that the information is, I believe it's real time.
Okay. We can hold the record open after this hearing to allow you to provide this information. It feels like it's relevant to the determination here. So that's...
Well, I would have to say that the information for the inventory that's stored in the warehouse in 2025 is different from any inventory that might have been stored when our business started in 2019. So in other words, there might have been 6 items in the warehouse in 2019, and now, and I'm not saying there was 6 items. I don't think there was any, but there might have been. I mean, we were just starting in 2019. So in 2025, now there might be an enormous amount of items. So I think it would skew. I mean, I don't mind providing the information, but I don't think it would be relevant because it would skew your opinion of the inventory, because we're making sales in California now.
Okay. So there's no information, just to clarify, historically dating back to the year that you did, only what's currently on.
There should be, because the respondent has said that they have this information. They have information that inventory was stored in the warehouse. It's part of their exhibit.
Okay,
But yet they haven't provided the information of what that inventory, that's another thing that I mentioned in my oral argument. They provide information that says that we had inventory, but they're not providing the information on what that inventory is and what the quantity was.
Thank you, Mr. Gerson. I understand that, but do you have, just to reiterate, do you have any historical information for the year at issue that you can provide?
No, we don't have,
Okay,
do not have.
okay, thank you. I'd now like to turn it over to the Franchise Tax Board for their presentation. Franchise Tax Board, you have 20 minutes to present, and you can begin when you're ready.
Good afternoon. My name is Alyssa Penerbasi, and I, along with Topher Tuttle, represent the Franchise Tax Board. The issues in this appeal are whether appellant owes the annual minimum franchise tax and whether appellant has established a basis to abate the delinquent filing penalty, the filing enforcement fee, and applicable interest. First, I will discuss whether appellant owes the minimum franchise tax. Every corporation is required to pay an annual minimum tax to California of $800 and file a return if it is doing business in California within the definition of Revenue and Taxation Code Section 23101. In the Presidential Opinion Appeal of GEF Operating Inc., your office found that Section 23101 included two alternative tests to determine whether a taxpayer is doing business in California. The first is found in subsection A and states a taxpayer is doing business if it is actively engaging in any transaction for the purpose of financial or pecuniary gain or profit. The second test is found in subsection B and includes a list of specific conditions which, if satisfied, will establish a taxpayer is doing business. Appeal of GEF specifically states that these conditions are not minimum thresholds and do not provide any safe harbor from the general definition of doing business found in subsection A. FTB agrees that appellant does not satisfy any of the conditions in subsection B for doing business. However, as your office stated, this does not prevent FTB from finding appellant is doing business under subsection A. In this case, FTB received information from the California Department of Tax and Fee Administration that appellant had sales in California during the tax year at issue. Because appellant denied having California sales or filing a sales and use tax return, FTB requested CDTFA provide relevant documentation related to appellant. The CDTFA had a similar filing enforcement process with appellant, which is important to this appeal because CDTFA determined that appellant had a filing requirement with California due to California sales and its physical presence of inventory stored in California warehouses. Section 23101 is coextensive with the Constitution, or in other words, if the Constitution permits a tax to be imposed, then the taxpayer is doing business within the meaning of 23101. Therefore, if there is substantial nexus for appellant to have a sales and use tax imposed upon them, then that suggests there is also a substantial nexus for an income tax to be imposed on appellant. The CDTFA enforcement began when it issued appellant a letter stating that it had received information that appellant had inventory stored in fulfillment centers in California. This required appellant to register with the CDTFA and file a sales and use tax return. There was then communication noted in appellant's account that the start date for filing would be the date inventory was placed in California by Amazon, and then appellant was issued instructions on how to determine the date stored and where the goods were stored. Instead of providing information that it did not have California sales or inventory in California, appellant filed a 2019 sales and use tax return on February 5th, 2020, and submitted payment that same day. This suggests that appellant reviewed its inventory and sales and determined it had a California filing requirement for the 2019 tax year. The CDTFA records indicate that appellant called in 2022 and stated that it had not conducted any business in California. However, its 2019 return remains on file, and appellant has not established that its 2019 filing was an error. Additionally, appellant has not produced any of its records. Your office has held in the Presidential Opinion Appeal of Vardell that failure of a party to introduce evidence which is within his control gives rise to the presumption that, if provided, it would be unfavorable. As such, appellant has not demonstrated that its filing with the CDTFA was in error or that it did not have sales in the 2019 tax year. Further, in addition to CDTFA's finding of appellant storing inventory in California and appellant's subsequent filing of a sales and use tax return reporting California sales, appellant's Amazon storefront also suggests that it engages in fulfillment by Amazon, as demonstrated in Exhibit K. Exhibit L details how FBA works and how, if appellant engaged in FBA, then Amazon likely stored appellant's goods in its California warehouses. Notably, in Exhibit H on page 4, there is a list of California fulfillment centers located in California. To be considered doing business under Section 23101A, the entity does not need to have a regular course of business. Even just one profit-motivated transaction is enough to be considered doing business, and that transaction does not need to result in profit as long as it was profit-motivated. Here, appellant had sales to California residents and also stored its inventory in California warehouses and therefore engaged in a profit-motivated transaction in California. Because appellant had a physical presence in California and California sales, it is doing business within the meaning of 23101A. In conclusion, appellant has not met its burden to establish error in FTB's assessment. Next, I will discuss the imposed penalty, fee, and interest. The late filing penalty was properly imposed because appellant failed to timely file a tax return by the due date. The penalty can be abated upon a showing of reasonable cause, but appellant has only argued that it did not have a filing requirement. Even if appellant is unaware of a filing requirement, ignorance of the law is not an excuse for failure to timely file a return. As such, appellant has not established reasonable cause to abate the late filing penalty. The filing enforcement fee was properly imposed because FTB notified appellant that it had a filing requirement and appellant failed to file a return by the prescribed due date. Once the filing enforcement fee is properly imposed, there is no provision that excuses the imposition of the fee. Appellant has only argued that it did not have a filing requirement, and therefore appellant has failed to establish a basis to abate. Lastly, interest is mandatory, and FTB does not have authority to abate interest unless authorized by statute. Appellant has not alleged, and FTB has not determined, that any statutory exception for interest applies. Therefore, interest should remain imposed. Based on the facts and evidence in the record, FTB respectfully requests you sustain its position. I'm happy to address any questions you may have.
Thank you, Franchise Tax Board. I'd like to turn this over to my panel now, or the panel, excuse me, for questions regarding FTB's presentation. Beginning with Judge Clutter, do you have any questions for the Franchise Tax Board?
All right, this is Judge Clutter, no questions. Thank you.
Thank you. And Hearing Officer Parker, do you have any questions for the Franchise Tax Board?
I have no questions. Thank you.
I did have one question, Ms. Pinnerbossi. So Mr. Gertson's pretty adamant that he did not have California sales in 2019. Are there any specific source documents that were shared by the CDTFA with the Franchise Tax Board that are in the record you can direct us to that show the California sales or inventory that was held in the California warehouses?
Unfortunately, I did not get those records from CDTFA. The records that we have are just appellant's own self-reported California sales.
Okay. Thank you, Ms. Pinnerbossi. With that, we'd like to turn it over to Mr. Gertson for the final presentation or rebuttal to FTB's presentation. Appellant, Mr. Gertson, you have 5 minutes and you may begin whenever you're ready.
Thank you. Again, absent any evidence presented here today from the respondent, there is not one profit-motivated transaction. There's no substantial nexus. They can't even tell us what the transaction was, and they can't even tell us what the inventory was. It is clear the response assessment for the 2019 tax year was made in error. Therefore, reasonable cause has been established for the abatement of the late filing penalty. In addition, the appellant has established a legal basis for the abatement of filing of enforcement fee and for the abatement of interest. Thank you.
Thank you, Mr. Gertson. With that, I believe we are ready to conclude the hearing. I would like to ask if FTB has any objection to holding the record open to allow Mr. Gertson to provide records for the California sales for 2019 that he states he has.
I have no objection. I will note that I did ask appellant to provide these records as well, and I have not received them, but no objection to keeping the record open.
Okay, thank you. We're going to hold the record open for an additional 30 days to allow appellant to provide these records. And I will issue minutes and orders following this hearing to state that and basically summarize the holding open of the record. And then FTB, would you like 30 days to respond to that? Whatever Mr. Gertson provides?
Yes, thank you.
Okay, thank you. So we will do that. We will hold the record open. And again, I will issue minutes and orders at the conclusion of the hearing or after we conclude. The record will remain open until we receive a full reply from both Mr. Gertson and Franchise Tax Board. The hearing is now concluded, and I'd like to thank everyone for attending. Thank you.
Thank you.
Thank you, Mr. Gertson.